Hi, I'm Nicole Palmer, and I'm here with a 2022 year in review of domestic and international patent practice updates. Over the past few months, the USPTO welcomed both a new director as well as commissioner for patents, both of whom have renewed the agency's commitment to promoting reliability and transparency in the patent process. A few logistics that practitioners, clients, and the public at large have made note of. First, the USPTO had a big release of what's called the Patent Center, an online tool replacing the public pair function. There was also a new patent public search tool issued with an emphasis on enhanced searchability. The examiners themselves have a new AI-based tool for searching available. Back in July, we had new requirements for sequence listings internationally going into effect, and the requirement for filing applications in docx format. The surcharge deadline has been pushed out a few times now. Most currently, we're looking at April 3rd, 2023 for the surcharge to go into effect for non-docx filings. Finally, in connection with some recent federal legislation, there was a significant reduction in the fee structure for small and micro entities at the end of the year. I also wanted to highlight a few updates and changes pertaining to the pilot programs available before the U.S. Patent Office. The Cancer Moonshot Expedited Examination Pilot Program replaced the Cancer Immunotherapy Pilot Program. We had an extension to February 15th, 2023 of the COVID-related fast track program. So we'll see if that gets further extended or not. The After Final Consideration Pilot Program has been extended to at least September of this year. The Deferred Subject Matter Eligibility Pilot Program ended the invitation phase back in June. So it'll be interesting to see what the Patent Office chooses to do with that. The Collaborative Search Pilot Program involving the Japan and Korean patent offices has been expanded and in effect through at least October of 2024. And we'll talk more about the PTAB, Patent Trial and Appeal Board in general, but the motion to amend the program, which provides enhanced opportunities for the consideration of amendments in the proceedings, has been extended to at least September of 2024. I wanted to switch gears and just highlight a few international developments. We've all dealt with the fallout of the conflict between Russia and Ukraine, even on the patent front, with the Ukrainian Patent Office having certain delays and impact on its functioning, as well as the USPTO taking action in terms of sanctions against the Russian Patent Office. In Canada, there were significant changes that went into effect in October of 2022 in terms of introducing excess claims fees, as well as something akin to the domestic US request for continued examination practice. So there was a big push to evaluate whether or not examinations should be requested in Canada prior to that October deadline in order to avoid excess claim fees. Turning to Europe, of course, we're all gearing up for the implementation of the Unitary Patent Court. The deadline for implementation was extended, pushed out to June 1st of 2023. So we're busy looking at whether or not applications should be opted out or not during the sunrise period that is anticipated to start in March of 2023. Regarding also European patent practice, we've gotten hints that the 10-day grace period rule might be suspended in the near future. and also a movement that the video-based opposition hearings were so successful that that's going to be the norm, at least for the initial hearings in EPO oppositions. Turning to Asia, Japan had some changes effective April of 2022, including the introduction of multiple dependent claim handling. China, increasingly looking at harmonization and instilling confidence in the enforceability of IP generally. Made some movement with respect to implementing patent term adjustment, patent term extension, and enhanced protection, particularly with respect to drug patents. Also, in terms of harmonization, both China and Brazil took steps towards joining the Hague Agreement on design protection. And finally, notably, in terms of the world stage, the WTO issued a ministerial decision on TRIPS, providing an IP waiver for COVID vaccines. And there's increased ongoing discussion regarding whether or not that will be extended to diagnostics and therapeutics pertaining to COVID as well. So that takes us into some other sort of trends or and legislative activity. Standard essential patents is still a hot topic. This past June, the US withdrew its 2019 policy statement on remedies for standard essential patents subject to voluntary FRAND commitments. So I think we're going to see much more on that. In terms of international efforts, there seems to be a renewed commitment and a lot of activity around combating counterfeits and piracy internationally. A few final points pertaining to turning back to domestic practice. Patentable subject matter is still very much a hot topic at the USPTO. The USPTO most recently requested more input on subject matter eligibility in general, as well as Section 101 examination guidance. And the USPTO put out a report summarizing public views on the quote article of manufacture requirement as well as part of the overall subject matter debate. The PTAB, I mentioned that earlier, we're now 10 years post initiation of the AIA, America Invents Act in general, and the institution of these various PTAB post-grant proceedings. And the Patent Office is really taking the opportunity to look back to ensure the certainty and fairness of the system and looking at any changes that can be made. The director issued guidance to the PTAB on permissible use of applicant-admitted prior art in IPR proceedings, which was an area where some clarity was requested, as well as activity in terms of parallel litigation and how that should be handled. We had the FinTEV decision, and the Patent Office put out interim procedures for discretionary denials in AIA post-grant proceedings with that parallel district court litigation, looking at the question of when should a panel deny to institute petitions for IPR or post-grant review based on parallel civil litigation or ITC proceedings. In general, we're seeing and forecasting an emphasis on AI and other emerging technologies and how this should be handled in terms of patentable subject matter, naming inventors, etc. We're seeing a trend in terms of agency collaboration. So recently there's been discussions between the USPTO as well as the FDA in terms of how patent information should be handled in the drug and pharma industry. Data privacy is going to be a hot topic going forward. A number of states over the past several months, years have adopted consumer data privacy laws, and I think we're going to see more states having that debate and implementing legislation. And finally, non-compete agreements. Most recently, We saw the FTC proposal to ban enforcement of non-competes broadly, and that will be an area of debate for sure. So a lot has happened over the past year, both domestically and internationally, and there are a number of areas where we're going to see more development in 2023 and beyond. Thank you.